Shall we begin? Shall we begin? I'm trying to understand, for the life of me, how I got a drug kingpin sitting in a cell sending the police to knock at my door.
I guess this is where I gotta come in. Listen, if you haven't heard, or if you haven't been, you've been on a rock for the last week or so. Supreme of the Supreme team, Kenneth McGriff, dropped the video. He really wasn't Kenneth McGriff. His nephew, geraldprincemiller, dropped the video, a documentary about Preem's life over the past, I guess, 50, 60 years, where he highlighted a few facts, a few things, one of which was the now viral conversation of Bimmy, James Anthony, formerly of the Preem team, being a confidential informant for the last 40 years.
You know, he goes away on conspiracy charges.
He had been arrested and prosecuted based on a search of a premises that he was in.
These were dirty cops who were working with a dirty, lying CI. Sergeant Foster and Myron Cherry both lied under oath just to try to arrest me. James Benny Anthony has been a CI for over 40 years. Benny is the CI they described in this search warrant affidavit and lies that two people were kidnapped and beaten in near death. It was a lie.
A lot of little things, a lot of stories, a lot of little content creators. I'm going to say little. I'm the little guy. A lot of other content creators have been having their own, conversation about that idea, whether or not Bimmy is a snitch, informant, rat, whatever you want to call him. Some say he is, some say he isn't. Some are looking for documentation. Some are saying that he has documentation. Shout out to Zip with the Drip. However, my forte, listen, I'm actually a lawyer, notwithstanding, listen, I'm from Southside. I've been, notwithstanding the background, but I'm actually, so I'm going to try to break down what Hassan Campbell is actually talking about with respect to this particular police officer, as he said. And this guy is definitely not a cop. He's none other than a process server because, to Hassan Campbell's point, he was actually sued. So this is the summons. This is the summons of the summons of complaint. And when I say summons of complaint, I'm talking about lawsuit. That's what a lawsuit really means. So this is the summons, and they put his information out there. Normally a lot of times you will have people, some attorneys like my firm particularly have a practice of putting the defendant's address, name and address on the bottom. And that's not, there's no CPL law that says that, but that's really to help the process server, because oftentimes, sometimes they may lose the address, or they may, transfer the information from the lawsuit onto another piece of paper, and sometimes they can make a mistake, put the wrong address. So we like to put the address right on the summons itself. So on this particular document, right? But again, that's not a part of this law, so there's no requirement to that. In any event, we're going to be keeping it real brief. It's only 8 pages in total, including the summons and the back page. We're going to keep it real brief. Let's go to the background. On October 25th, 2025, the defendant published a broadcast podcast episode titled Supreme McGriff Lashes Out on Supreme Jr. I don't know if you remember, but this was around the time that, it's kind of went viral. I didn't cover it. It's kind of went viral where Supreme's son, I don't even know what the hell his name is, but in any event, Supreme's son was doing a lot of antics. He was going back and forth with 50 Cent. In fact, he had 50 Cent's son. He took a picture of 50 Cent's son and posted it, essentially to troll 50 Cent. As you know, 50 Cent and Supreme have their function, have their little beef. But Supreme was like, nah, you need to fall back. And according to the way in which the spilled out, Supreme has been warning his son to stop doing that because they are working on certain things, and the last thing you want to do is create any unnecessary friction, especially if they are trying to put out or portray that they are, anti-violent, anti-crime, the life they once lived is far behind them. The last thing you want to do is keep close to the flame, keep close to the fire, especially when you look at the connection between these two factions, where it was a violent, almost deadly end result, right? So, according to Supreme's son, Supreme sat him down.
Due to recent events, the elevation to a place of peace and rest for my brother and friend, Irv Gotti, and the buffoonish display of my son, Kyle Robinson, I am forced to make a public statement in defense of Irv and his family. I do not indulge in idle chit-chat. When I speak, I have something to say. Kyle Robinson does not speak for Irv or Irv's family, nor does he speak for me or my nephew, Gerald Prince Miller. I was disgusted when I heard about the things he said as far as representing Irv's family.
So back to the lawsuit. On or about March 25th, 2025, defendant published broadcast podcast episode titled Supreme McGriff Lashes Out on Supreme Jr., which was publicly disseminated to an audience exceeding 70,000 viewers on online platforms. In that podcast, defendant falsely, maliciously, and recklessly stated plaintiff was the biological father of 50 Cent, of rapper 50 Cent, categorized him as illegitimate. Plaintiff ordered the murder for hire against 50 Cent. Plaintiff killed 50 Cent's mother. Plaintiff abused and neglected his own son, Kyle, Little Preem, leaving him for dead on one or more occasions. Plaintiff was a deadbeat father, had never brought his son a pair of sneakers, hadn't spoken to him in 7 years, and never loved him. Plaintiff was a filthy NR, nasty old NR, and a piece of Plaintiff had Kyle's mother shot to induce a miscarriage, falsely stating the plaintiff never wanted Kyle to be born. Defendant made these statements with actual malice, personal animus, and a specific intent to embarrass, discredit, and harm plaintiff. Defendant publicly acknowledged during his podcast that he had a troubled and unresolved relationship with his own father, and that he was emotionally triggered by public statements the plaintiff had made about his own son, Kyle, also otherwise known as Lil Preem. In retaliation, the defendant admitted that he intended to expose and destroy plaintiff's image, making false, defamatory, and incendiary statements for the purpose of public shaming, humiliation, and retaliation. Each of the above statements is demonstrably false, defamatory, and not protected opinion, and was made with actual malice and reckless disregard for the truth. Defendant weaponized his platform, reaching tens of thousands of viewers, to mischaracterize plaintiff's family life, parenting, and criminal history in a matter calculated to stir outrage and cause reputational destruction. Following the publication of defendant's March 25, 2025 podcast, at least two additional podcast hosts with a substantial online following rebroadcast the original defamatory statements on their own shows. These representations exponentially increased the damage to plaintiff's reputation, and character, causing the defamatory conduct to reach hundreds of thousands of viewers and listeners. It is reasonably foreseeable that defendant that making such inflammatory and false accusations on the platform will result in republication and widespread dissemination, especially in an environment where podcast content is routinely shared and re-aired across multiple digital media channels. As a result of the initial publication and subsequent republications, plaintiff has been subjected to nationwide ridicule, hate-filled commentary, threats, and additional emotional distress, further harming the ability to pursue business ventures, protect his family's name, and seek relief through the pardon process. Plaintiff has never committed or been found guilty of any such acts and has been cleared of any related accusations by the appropriate authorities. This motive supports a clear finding of actual malice and further undermines any defense of opinion or mistake. Damages. These false statements have caused severe emotional distress, damage to plaintiff's personal, familial relationships, harm the plaintiff's representation. I keep saying representation. Harm the reputation and public standing. See, listen, I went to public school, so you gotta, I went to law school, graduated law school, and all that, but I went to public school nonetheless. So you gotta bear with me. Interference with business opportunities, including active negotiations for the documentary about plaintiff's life, which have now been stalled. Public humiliation and embarrassment. Jeopardy of plaintiff's life safety while incarcerated, particularly given the allegations of crimes against women and children, can trigger retaliation and prison, violating unwritten prison code, interference of plaintiff's application of federal pardon, damaging his prospects, and retaliation. Cause of action, and it gets into the cause of action. Let me just say this. Oh, he asked for $3 million. Sheesh. Wherefore, he asked for $10 million. And of course, they got to throw. Of course, the lawyer got to throw that one in. Let me say this. I saw a few people speaking about this. A lot of people made commentary saying, well, Preem is a convicted murderer. Preem is never coming home. He has life. Notwithstanding that, there is an abundance of cases where, regardless of who the individual is, if you make a false statement concerning the plaintiff to at least one other person that's not privileged about said plaintiff that damages his reputation, you have defamation. And in this instant, just merely saying it, which is slander, you have to prove damage. But when you say, yo, he ordered the murder for hire against 50 Cent, or he attempted to unalive his, child's mother, and all of these like infamous acts, it's 4 things that will render those statements slander per se. Slander per se is a specific rule that says you don't have to prove damages when it comes to defamation. It's either slander, which comes out of your mouth, which is a statement, or libel, which is a publication, like you wrote it and published it. In this instance, it's slander. Now, slander per se says, if you make a false statement about a person's chastity, if you make a false statement about a person's business practices, if you make a false statement that somebody has some incurable disease like HIV or herpes or what have you, or if you make a false statement that's about somebody committing an infamous crime, you don't have to prove damages. So while a lot of people are saying, well, Supreme is this infamous figure, like his reputation already shot, not necessarily, because he still has a pardon that he could pursue. He still has potential book deals and movie deals and all kinds of stuff. While people, Preem is somebody that's of the past. He's a former or current gangster, however you want to call it, and his time came and went. But like most, mob movies, gangster stories, these are like, timepieces. These are evergreen content, so to speak. Like no matter how old Al Capone is or how old that story is, if they come up with a new Al Capone with Al Pacino playing it, people are gonna flock. Just like with American Gangster and Denzel Washington. When Denzel Washington played Frank Lucas, who he was, blockbuster hit. Right? All of these guys, notwithstanding their past or what they may have done and been convicted of, they still could generate income. They still could generate fees. They still can get some sorts of relief. And if you have these things out there, right? You have these little pieces, these lies, so to speak, out there, it could actually damage their home. One particular individual specifically, I was paying attention to 50 Cent was considering doing a new Paid in Full. One of the figures from Paid in Full, that's the Al Paul, Rich Porter story, and AZ story. One of the figures, the infamous figures of Paid in Full, was this individual named Wayne Perry out of DC. Now, it kind of stalled, to my understanding, because Wayne Perry, because of some federal agent, and then it was exacerbated by other individuals, I think Sean Branch, they said that he was engaging in homosexual activity. Now, because they said he was engaged in homosexual activity, to my understanding, 50 Cent or whomever else that was trying to create a documentary about Wayne Perry wanted the actor to portray that role, and that was a direct hindrance because some actors aren't comfortable, and according to Wayne Perry and his family, it's not true, right? That directly affects his ability to earn. It's a business opportunity. It directly affects it, right? Now, that's not an infamous crime. that's not a chastity thing, because chastity is about virginity, which is really for women, so to speak. But that's just an example of what could happen when you make a statement and the damage thereof that it could cause. In any event, this is an interesting case. I'm entirely interested in what Hassan Campbell has to say about the end result, whether or not he's going to answer, whether or not he's going to respond, or whether or not he's just going to stay on social media and talk about it in default. Right now, fortunate for Hassan Campbell, they didn't sue his publication, they didn't sue his channel, which I'm kind of shocked that they didn't, because he said it on his publication, so they actually should have listed his publication as one of the defendants. But whatever. Hassan Campbell is named as Hassan Campbell, so he could represent himself pro se. If it was his company, then he has a lawyer up. And I'm interested to see what's going to happen. Anyway, y'all stay tuned. I'm Mr. CKB, and I'm out.